Welcome to Lanson Law. My name is Ron Lanson, Principal of Lanson Law, and today's micro webinar will be on the corporate practice of medicine. So as part of our disclosure, we wanted to say that this presentation is for informational purposes only and not for the purpose of providing legal advice. Use of and access to this presentation or any materials contained within this presentation do not create an attorney-client relationship between Lanson Law and the user or viewer, and you should contact your attorney to obtain advice with respect to any particular problem or issue. So what is the corporate practice of medicine? Well, according to the IRS, the corporate practice of medicine laws require corporations created to employ physicians in an outpatient clinic to be incorporated under the state's professional service corporate laws. The laws also require all providers of medical services to be licensed. Often the laws mandate that all stock in the corporation providing the services be held by a physician licensed in the state, and all members of the board of directors be physicians licensed by the state. So how are states looking at this issue? While the corporate practice of medicine is sometimes an ambiguous area, especially for non-physician professionals, some states don't have these statutes and some do. So it's imperative that you understand which state you're operating in. New York, for example, has Section 1507A of the Business Corporation Law, which states, a professional service corporation may issue shares only to individuals who are authorized by law to practice in the state a profession which such corporation is authorized to practice, and who are or have been engaged in the practice of such profession in such corporation or predecessor entity, or who engage in the practice of such profession in such corporation within 30 days of the date such shares are issued. So in other words, if you're forming a professional service corporation, it has to be within that industry that you're forming that corporation for. So how do the courts look at this? Well, in 2019, the New York Court of Appeals, which is the highest court in the state, ruled in the Carruthers, MD, PC versus Progressive Insurance Company case that only licensed physicians may practice medicine in New York. The unlicensed are not bound by ethical rules that govern the quality of care delivered by a physician to a patient. By statute, regulation, and the common law, the corporate form cannot be used as a device to allow non-physicians to control the practice of medicine. So in other words, looking at just New York as an example, it is imperative to be informed and to speak with your counsel about your options when you're looking at the corporate practice of medicine. Thank you very much for listening. If you have any questions about this educational piece, here's our contact information. Thank you so much.